Public land survey system. So, I mean, a lot of us are West Coast surveyors, and so this is one we understand and kind of get into. But uh, Jeff goes through this, and in his podcast that he did a while back, he talked quite a bit about kind of the first surveyor concept that he brings up. And so what we'll talk about today is a little bit about what it means to be the original surveyor for the PLSS, what is the intent, and what did the original manuals and letters say, and then kind of how that gets into our retracement. And so to kind of start us off, just share a little story. So Utah had our conference last week, and we were just talking about a bill that we've been pushing. But one of the nights after the conference, we were actually in the hotel lobby, just sat down talking, a few random of us, and as people walked in and out that night, they kind of joined in. We actually had a pretty good group. It was kind of fun to sit there and chat. But we actually had one of the surveyors from a more rural part of the state there, and then we had a bunch of our more urban surveyors there, and we got into a really interesting discussion about the PLSS system. So where I generally practice is Salt Lake, Davis, and Weber County. Those are the three biggest counties in the state. Pretty much every section corner is in that can be, or they've been surveyed within the last 5 years, or something like that by one surveyor of another. So there's not a lot of, what we call breaking down or retracing the sections. You show up, the monument's there, you start your survey, you tie to it, and by and large, there's very little error in where those monuments are placed. By and large, I see John laughing there a little bit, but certainly there are monuments that have been moved and reset poorly by other surveyors, and there's certainly deeds that tie differently to those corner locations as monumented. But my job's pretty easy because I can show up, I can do it, and I'm not finding a lot of error in that. But this surveyor who works in kind of a rural eastern area of the state, most of those corners haven't been seen in 20 or 30 years, and most of them have not been reestablished since the original one. A lot of them are original stones. There are no corner records or what we might call a township reference plat that gives, record measured bearings and distances that are more modern measurements between corners. And so, he was complaining about us city surveyors that would go out to his part of the state and start surveying and have no clue what we're doing because we're so used to just showing up and having a corner there, and we keep screwing up the surveys out where he's at. And we had a really great discussion about, the BLM manual, and this book focuses a lot on the 1973 manual because that's what most of us have surveyed under. The 2009 really didn't have a lot of major changes to it, but when the Pincushion Effect came out, the 2009 manual was rather new and not a lot of people had it, so he just kept his focus on this. But there's certainly a lot of manuals that I think we forget to kind of check back into, and what procedure is when these original surveyors set these corners originally and how they were instructed to do that. And then once it falls into the public domain, how are we supposed to approach that? Whether it's, looking at occupation and deeds and intent and how it's been used and how that entryman first established those, or original surveyors established those, versus what did the manual say needed to be done, may not have been done back then. And so we got into a really great discussion. So I'm hoping today that we get into some of that back and forth as we talk about it. So I share that just to kind of preface that hopefully we can look and identify the differences between the manuals versus how we might do it today as private surveyors in there. So So to start here, I want to just read out a 7.02, just jumping into the intent of the original grantor. We always talk about intent in retracement. So it says here, when it comes to the study and interpretation of written documents, whether those documents are deeds, contracts, or any other written instrument, the first inquiry is the intent of the parties to the transaction. Any study of the PLSS should have the same initial focus. So really, the intent was laid out in this land ordinance of 1875, and it says, and it's the final version in May 20th, 1875. The act reads, "Be it ordained by the United States in Congress assembled that the territory ceded by individual states to the United States, which had been purchased of the Indian inhabitants, shall be disposed of in the following manner." And that's what these books are, these manuals of instructions and these letters to specific surveyors. And it would establish the mode for the first surveys of the public domain in what would be commonly referred to as the 7 ranges in present day Ohio. The primary parties to any land transaction under the PLSS are the federal government as grantor under the system, and the grantee being the individual who derived title from the government. And the grantee is often referred to as the patentee because the government would issue letters patent upon purchase of the property under the system. This individual also is commonly referred to as the original entryman, an acknowledgement that under ordinary circumstances, the grantee was the first to enter upon the land under patent from the federal government. And just as these terms are used interchangeably there. And so as I started surveying, these are words that I heard and kind of glazed over: the patent or the original entryman, original surveying. You start glomming on to only bits and pieces as you start learning this. And so this was kind of good to rehash. I would say I understand a lot better now. We traced many surveys back to patent, to that original letter. But I wanted to throw it out to the group. Your guys' experience as surveyors, how often have you gone back to patent or look at that in our different areas of the country, and what might that look like there to start the discussion here, as far as researching and looking into that?
Somebody's gonna have something. I would say, most surveys do go back to patent because we're always checking for patent easements. Those are really important, whether they've been vacated or not. So that's always going back to that original document that kind of created the parcel to begin with. So
Yeah, ours are rare. I'm in Northern California, and if I look at a patent, it's probably just to determine if it's a legal parcel or ownership, historical ownership research. I usually am not looking at patents for survey data, um, but I do occasionally go to the field notes for survey data and review topographic calls, and I've gotten a lot of information out of those, the BLM field notes.
Yeah, I would second that. I work in the same area as David, and we really rarely pull patents. We'd pull a patent, like you said, for to do title rights, to maybe to start a chain of title. Sometimes we have to go back that far, but there's very little survey data in the patent, so it's rare that we would pull a patent.
Okay. I'm kind of the same way. I mean, it depends on the survey, the type of survey, the level that's needed. But in most retracements, I am going back a couple landowners just to look at continuity. If, for example, I start seeing some discrepancies, we start tracing that further and further back, and sometimes to patent. Utah being a fairly young state in the union, in many areas, it's not hard to get to patent within just a couple of generations or a few deeds. But you do gotta make the effort to get to the county and kind of chase that a little bit.
In my area, Arkansas, most of the section lot surveys were done in the 1830s, and we always had copies of the township plats and the transcription of the field notes there at the county. But our courthouse burned in the 1890s, and so the patents aren't available to us. But I'm not sure just exactly how they started out with the land records and title after that, but somehow or another they muddled through. But so most of my research was done to the plats and to the field notes, and I did that on a regular basis. It was imperative to have some kind of data to prove the location of section corners and quarter corners, which in my state were the only corners that were physically set on the ground. So they are the only points that from that survey that are granted original monument status. I don't know how it is in your state.
So I'm curious, yeah, having the courthouse burnt down there and losing those records, I in the back of my mind, but maybe someone correct me, are those patents also stored back in Washington D.C., a duplicate there from the federal government as a grantor of those, if need be, to chase it that way?
Uh, they might be, and maybe that's the way they started out with title, but the local courthouse does not have any physical copies that I know of or ever saw of the original patents.
Okay. Thanks, James.
I would reiterate what James said too. We pull field notes all the time. Field notes they're gold when you're out finding original lines. You know, the topographic calls or the markers they set or any information you can glean out of there is great.
Yep. You know, again, these patents were often aliquot parts, and so those field notes help break down and understand that section. So great. So maybe with that, where in your states do you guys go to get those original field notes? So I know in North Dakota, when I was doing work there, the Water Resource Board had a repository of those, so that was the easiest place to get them there. But here in Utah, our local BLM office has them all indexed, and we can just get on the BLM page and find those very easily. But any particular place you go to find some of those original notes? Go ahead, John.
The Bureau of Land Management has usually they used to always have your local states websites that you could do research on. Well, now there's a GLOrecords.blm.gov site that they've got most of the country on. You can get the copies of the original surveys, the field notes, and the patents as well as other extraneous information, executive orders, land records, all sorts of stuff. And they're constantly putting up more and more on that site. I used that instead of even going to our local Utah site because it's so much better, and the copies of the scans and stuff are a lot better. You actually get see, all the records with BLM were filed in triplicate. So all your patents and your surveys and field notes were filed in triplicate. One went to the local land office, one went to the your regional archives, and then one went back to the National Archives back in DC. And a lot of times they'll have scans of the duplicate plats as well as the original plat, the duplicate plats, and sometimes you'll even see the triplicates that have been scanned. but it's excellent quality of the stuff and really easy to find the information. I just popped it up just because I was curious to see if Oklahoma is there, and yeah, the Oklahoma's on the list um, for at least for the patent list. I'm sure they're on there for the surveys as well.
Okay, wonderful. There's another great resource for us. David, you've got your hand up. Go ahead.
Yeah, we can get maps on the BLM website of the whatever the section plat, the township plats. But and some field notes are available. Most of the time, we have to send an email to the field office in Sacramento, and they're pretty responsive. They'll turn around and send us the field notes. I don't know if they have them all scanned or if they scan them up by request or a little bit of both. And that's pretty much our process to get the field notes, the BLL, the survey, actual nuts and bolts survey data. But one interesting aside is that we get old surveyors die and donate their records, so the county surveyor's office will end up with a bunch of old junk basically. And I have seen field books where like old leather bound field books with cursive writing in them, where people have old surveyors would go in and copy those field notes into their field book, presumably for, just purposes of having their own library or for taking those books to the field so they could use them in their retracement. But it's kind of spooky to see this like old leather bound book with with the field notes in it, and then you think it's something important, but then you get a copy of the field notes from the email, and they're identical. So there's no real value to these old leather bound field notebooks, except that they're transcriptions of the government notes.
We had a surveyor that first practiced as a county surveyor in 1895, and then he returned to surveying about 1930. And he was quite a knowledgeable man at that time on surveying, and in the county's notes or record of the field notes from the GLO survey, he inserted some additional information in there on corners that he had recovered, and he would include there in narrative fashion what he found at the corner and what bearing trees were there, and all of the information that he used to reestablish the corner. And then he would set a durable monument there. Sometimes it was a stone. He also had access to some light rail, railroad rail that was used in the mining industry, and he might have a 6-foot piece of that buried 4 feet and sticking out of the ground 2 feet to monument one of those section corners or quarter corners. And those notes were just invaluable in the places that he did that. And I guess the only one that ever knew that they were there were people that poked around in the records of the county and found that old book with the BLM field notes in it. I did, but I don't know whether there was any other surveyors that ever made access to that or not. So there are sometimes records there at the county level that you have to be local and spend some time down there to find them.
Absolutely, some great resources there. I spent the morning at my county surveyor's office as they're starting to digitize quite a bit and learn quite a bit of stuff that I didn't even know they had there, and old maps and stuff as they've pulled out the the filing cabinet they didn't even know they had there. So it's always great to dig around as you're finding challenges in retracing surveys and going back. Continuing on in the book here, I thought this next little bit was curious. So in the book Measuring America, there's this little quote out of it. It says, meets and bounds surveys did not just produce shapes that only the best surveyors could measure. It created a maze of bureaucratic form filling that invited fraud and wholesale corruption. In practice, the procedure was complicated further by inaccurate maps drawn up by poorly trained surveyors, and by the mistakes made freely or for bribes by inadequately paid registrars and land offices, so that legal claims were forgotten or predated. He brings up this case in Georgia. So in Georgia, speculation crossed the blurred line into outright fraud. In 1795, Spain relinquished its claims to Georgia's Western Territory. Within months, both houses of the Georgia legislature passed legislation selling 40 million acres, much of modern Alabama and Mississippi, for just $500,000, although only half the sum was actually paid. It says the sheer scale of the fraud has prompted one modern analyst to compare Georgia at that period to modern Russia, where powerful cartels aim not only to break the law, but to use it to legitimate their criminal activities. That's really interesting. I hadn't heard that story before of some fraud in land retracement and land sale, at least to that level. And so that's kind of the environment, he says, that the PLSS was created. And it creates this really clean system in which to track very unique identifiers to every piece of land. You have a basin meridian, a township, and a range, and then the aliquot part inside of a section that clearly identifies everything and helps it to be retraced. And the idea was that this would all be marked out on the ground in equal parts. Next, Jeff brings up the story of the first conveyance that took place in the PLSS system. So it was in New York on March 4th, 1788, to this John Martin for the sum of $640. It was Lot 20, Township 7, Range 4. That patent was for 1 square mile section of Northwestern Territory. And so the interesting thing is particularly in this case, this was sold off before it was really ever surveyed down to that lot level, according to the book here. And so this is where the challenge gets to in retracement surveys, as it says in here, when Martin received his patent from the federal government in New York City for Section 20, existing in the 7 ranges of Ohio, only the lot and township corners around the exterior boundaries were monumented. The corners were marked using either wood post or corner tree witnessed by 2 bearing trees. No doubt these corners were set for the purpose of further subdividing the township into the various sections called for in the official plat. However, Martin's corners were not physically on the ground. What was the federal government's intent with regard to Martin's corner? His lot was 2 miles from the nearest range line and 1 mile from the nearest township line. And Jeff gets facetious here. He says, was he supposed to wait till 2011 when some surveyor finally would come along with his GPS and get it right with proper procedure? The only logical assumption back then was whatever was monumented, whether it was this Martin going out and doing a good faith effort to locate it as best he could and document and occupy the area he is, or the federal surveyor. But once it's marked, again, the original intent was to give him this 1 mile square, this lot 20. And even if the federal surveyors went out there and did it, it wasn't going to be exact. The way in which they measured, the accuracy in which they could do that with the tools they had were that of the time of 1788. They weren't this GPS we could go out there with, millimeter accuracy and go set a point on the ground and call that one correct. And so the intent of these federal grants was the entrymen were supposed to go occupy it and claim it, and that becomes the area. And the problem is we come in today and say, well, we can measure better, we can interpret the manual better and our understanding of that, and re-break down a section and reset these property lines, although they have been occupied too by, say Martin here. So it says in here, down at the bottom of page 210, help in this matter is available from the manual itself. Chapter 3 of the manual deals with, among other matters, the subdivision of all sections. Section 3-76 specifically deals with the intent of the original grantor when it came to further subdivision of the sections once the government surveyors had left the field. And it reads, the local surveyor is employed as an expert to identify lands which have passed into private ownership. This may be a simple or a most complex problem depending largely on the condition of the original monuments as affected principally by the lapse of time since the execution of the original survey. The work usually includes the subdivision of the section into the fractional parts shown upon the approved plat. In this capacity, the local surveyor is performing a function contemplated by law. He cannot properly serve his client or the public unless he is familiar with the legal requirements concerning the subdivision of sections. So I just want to kind of pause and talk here and kind of get some discussion from the group. What is your understanding of your role as a retracement surveyor, in regards to balancing the BLM manuals and the GLO manuals, and also the private rights of the landowners that have occupied some of these sections? Go ahead, James.
I can take that. If nobody wants
Yeah.
to go
Nobody-
at it,
nobody's jumping
I'll
on
be
it.
happy to.
Yep.
Start our discussion off for us. Get us going.
Well, in my area, most standard sections, you start out with 8 original corners, the 4-section corners and the quarter corners. And those are given the special authority of any original marker. So, and there, we start out, or I'd like to start out with the basics there of what the authority is and why it gets that authority of original monument. And that's the fact that rather than what is written on paper in words or drawings versus a physical monument on the ground, the physical monument better expresses the intent of the grantor. And that's true whether we're talking about GLO surveys or we're talking about modern surveys. That is the thing, the basis of why an original corner is given the special authority to be a controlling corner regardless of where it is actually on the ground. So we start with that. And these 8 corners were placed in there. Now then, also a basic thing is that where you have a boundary course that has a controlling monument at each end, the boundary established from those monuments is a straight line between the two unless there is language that would indicate otherwise. So when they set those quarter corners, they set the boundaries between, like the north and the south quarter corner set the boundaries between the east half of that section and the west half. And the east and west quarter corners set the boundaries. They established the boundaries between the south half and the north half. And there's been nobody that had any authority to change that. That's that's the boundaries or boundary lines. Nothing about the center of the section is monumented because it wasn't monumented, but it was effectively established from those quarter corners. Right there when they did it, as soon as the first patent sold land in that section, that was fixed. We have to live with that. Now, the fact of the matter is that the people that came in there and surveyed weren't very good at locating where that intersection occurred. And sometimes it was way off, but sometimes the adjoining owners took that and verified or ratified the use of that erroneous monument for their corner. You know, I know Lucas always says there's only one corner. Well, there is only one corner, but there is a boundary marker all over the place that is controlling against adjoining landowners by reason of their acceptance, their use, or non-objection, causes those erroneous boundaries to be, for all intents and purposes, for their use, the center of the section. But you have to remember this, that only applies to those people who have been involved in that erroneous corner, who have ratified it by their own use. Somebody that is removed from the center of the section, let's say for a 16th corner that's away from the center of the section, that has no knowledge of what those landowners have been doing over at the center of the section, who has no reason to bring suit or against those people, because his line, his position hasn't changed, and it can't be changed by what landowners in the center of the section decide that they will use for their corner. So you really wind up with a situation of two things when you go to stake one of those 16th corners, where that guy, the owners there, have not been involved in what went on at the center of the section. Their proper corner is a standard breakdown of that section. You find the center of the section as an intersection, and you set the 16th corner off that. That doesn't mean that those guys over there in the center of the section have to use that. And for me, I never even set a monument there. It only confused those people over in the center of the section. But I'm not going to let some guys in the center of the section have their usage or what they agreed to interfere with the rights of my client who is removed from that area. Does that make sense to y'all?
Yeah, we've got a couple of hands here, so let's make sure we've got questions or comments. So Matthew, you had your hand up first. We'll let you go, and then John's got his. And Jeff, welcome. We'll introduce you here in just a second and let you get your piece in here. So go ahead, Matthew.
Thank you. I just wanted to augment on what James was saying. It reminds me of my favorite section in the 2009 manual, and that's 3-137. This is where they talk about bona fide rights, and he didn't use that word, but I think that's what James was talking about. And I won't read it to you all here, but I think that's a section. It's maybe 1 page long, and it's a summary at the end of chapter 3 in the manual. That's worth reading because it talks about these issues that James was just talking about, or that we're kind of dancing around here, that there are entrymen, things get marked, maybe not the right way, whatever. But bona fide rights are established, and that weighs on your survey. And I just wanted to bring that to everybody's attention. Again, that's 3-137. Check it out at some point. I think it's, again, it's my favorite part of the whole manual.
Okay, and we will get to bona fide rights at some point in this chapter, whether it's this week or next one. We'll see how far we get today. So, John, go ahead.
Yeah, I can certainly dovetail off of Matthew's comments on the bona fide rights thing. I think we get into this place where we if we went out and we found a section corner and a quarter corner and measured the distance between the two, is it going to be 2,640? Is it ever going to be running north and south? No, they're not. There's error in all of the monumentation. So when we go out there and we now pin down the east and west quarter corners and we have this theoretical straight line. When those lines were run out on the ground and that center section corner was placed at an intersection, yeah, there's error. And there will be bends at the intersection at the point the center section. The monument and the monument, it's just not physically possible for surveyors to set it in the correct position, the mathematically correct position. And so but once that corner has been set and accepted by the parties, as James was alluding to, and you've got that evidence of their acceptance, now you've got a monument that is taking on all of the properties and intents that the landowners have in placing that monument. It becomes a good faith position, a bona fide establishment of that corner. And it's not going to be in the original position or the mathematically theoretical correct position. Never will be. Neither will be the 16th corners that are set off of that. If that center section corner is off, and now you want to set the east center 16th corner, do you set it at midpoint between the two monuments? That's what the manual would say. Or do you use a mathematical position for the center corner and use that with a physical monument on the east quarter corner and try and midpoint that and do some mathematical gymnastics to figure things out? It's not about the math. Boundary surveying is done on the ground, and that's what we do as original surveyors, to set it on the ground. And once it's set, my job is to retrace that line and basically end up in the same wrong location for the same wrong reasons that the first guy ended up in the same wrong position.
But John, this is just too far off to logically hold, right? There's no way they intended to be this far off, so I've got to correct it.
Yeah, and how can a surveyor being 50 feet off on a center section corner now move a 16th corner by 25 feet? Oh my God, oh my God. Yeah, they're not right. If the quarter corner was off by 50 feet, would we be having this discussion? No, you accept the quarter corner, and we don't even think twice about it. And yet we get all hung up on mathematics and some reasonable expectation of precision or accuracy on a center quarter or any interior monument. We're just surveyors setting points on lines, and we do it the best of our ability. And hopefully they didn't do it 100 years ago, because I can measure better today.
Yeah. Okay, well, David's got his hand up. We'll let David go ahead here.
Yeah, this is I mean, I'm pretty much in agreement with the other people that spoke. Generally, ever since I started drinking the Jeff Lucas Kool-Aid, I stopped breaking down sections, and now it's more of a evidentiary exercise of finding the prior establishment, or confirming existing survey data that's already on the ground. I've gotten in very heated discussions with older, wiser surveyors who still go out and do that. Find the section corners and put the new quarter corners and center quarter at midpoints, and blow right by the old wire fence, or adjacent quarter corners. Now I did have also, we've got a lot of timberland in my area with, there's not a lot of physical establishment on these aliquot parcel lines. just woods, but you still can usually find evidence of prior survey and bearing trees and that sort of thing. And you mentioned looking 50 feet off or a couple 100 feet off or whatever it might be. Um, if I determine that the corner's lost and I just can't find it, then yeah, I'm gonna reset it. But it's not common, and I've got buddies that have worked with BLM and that sort of thing, and I never have personally, but they go out and they have what I perceive to be an unlimited budget to go look and spend as long as it takes to stumble around in the woods and find these old stumps and stones and pits and rock mounds and corner, whatever's still there, bearing trees. Um, and so that's what's expected of us. Depending on the day, I might give up a little sooner than that and just drop a pipe in the ground at the midpoint if I really can't find it. But that's the general rule. Now there was one situation that I'd like to remark that where we had a locally accepted corner that was documented on an old record of survey, and the note on the survey said that the landowners had accepted this corner. Now that corner was not based on a section breakdown, and I'm sure this is common where people just run one line out of the section and set a post at 1320 or whatever, and everybody rolls with that for 50 or 100 years. Um, and I tend to say that those should be honored for the reasons already discussed. But one time I had one that was you know demonstrated on a record of survey and documented that everybody accepted it and used it and relied on it. And then somebody went around the rest of the section and broke the whole rest of the section down in the standard fashion and left this huge gap between this locally accepted line and the rest of the subdivision and the rest of the section. So I ended up closing the gap and going through the proper methods to do that, but it was painful to just like disregard that prior accepted line, but I didn't want to leave a strip of no land in there either. So it worked out. That's all. Thank you.
Thanks, David. Well, Jeff, welcome. We've missed you the last few weeks. I see a couple new names in here. I don't know if you're dragging any Oklahoma folks in here, but I just want to ask what was for dinner. Do you have fried okra, fried bologna, and fried fries and everything out there?
Yeah, everything's fine here. Yeah, I didn't really know what I was getting myself into when my wife kept asking me, well, what about Oklahoma? What about New Jersey? What about New York? I ended up doing seven conferences in 2 month period. That was this is number seven. That was a little tough, a little unexpected. I got to pay more attention to what she says to me.
I like it. Well,
But the,
I mean, we're just a couple pages in here as you join us into chapter 7. We kind of talked
yeah,
about the
that's
intent here and get into discussion of what is our role in regards to the original
Un,
BLM manual, so
un
breaking it
tonalea,
down versus
un tonalea.
our role is as far as retracement surveyors in the private realm and how we balance the two instructions and methods in our work.
yeah, yeah. I kind of got caught up on the conversation here. Um, yeah, the thing is, and I'm kind of glad I don't work out in some of the western states where this is going on all the time. I mean, I'm really kind of glad about that. Um, but I guess my feeling is some well-intentioned surveyors back in the day went to their legislature and they say, hey, we got this BLM manual thing here, and we want it stuffed into our code section so that we have some guidance. I mean, I can see that happening. And I imagine how that happened out west. But the biggest, I mean, just step back. I mean, it's not a retracement. It's not a manual for doing retracement surveys. It's a manual for doing original surveys of the federal lands. It just doesn't make any freaking sense. And I have it I have it in this section. There's one place where the manual talks about retracement surveying. It has nothing to do with lost corners, nothing to do with proportionate measurement. So it's just how did this? I wonder how did this happen? How could we take a manual for the original surveys of the federal lands and try to turn it into a retracement manual? It's like trying to drive a round peg into a square hole. It's mind-boggling, really.
I think as I've been studying this, we've had these discussions. It's this challenge we have as surveyors is we're told to retrace, right? And if we're going to retrace the original BLM monuments and follow in their footsteps, we're going to follow the manual to retrace. And that's like you said, that's not right. What we really should be following is not in the manual that they used, but in their literal footsteps of how they applied the manual, right? The good faith was that it's going to be 2640, but the truth was it isn't. And we get lost in that retracement aspect of respecting what they did, but respecting the wrong part of what they did. We need to respect how and where they did it, not what they were told to do. Does that make sense? In my mind, that's how I justify it.
Yeah.
How we got to where we did.
And this part of the chapter is, what started out with, John Martin's, dilemma. None of his corners were set, and so what did the federal government expect people to do? And I think, we didn't live back in those days, and we can only speculate as to what people's ability to measure was, but to the whole thing, at least from my view, and I'm going a little off script here, I don't even talk about it in this chapter, but one thing I've learned over the years of being a surveyor is it's all about the people. It's really not about surveyors. And surveyors, we like to make it about us. It's proper procedure, proper procedure, proper procedure. There's no mandate for proper procedure. There was a mandate for the BLM surveyor, the GLO surveyors for proper procedure, and when they break a section down, they're supposed to run straight lines between the opposing quarter section corners. And then if they find a corner that they don't even want to spend any time looking for it, they just call a corner lost, and they can bring it back in with double proportionate or single proportionate or whichever proportion you're supposed to be using. And they can do that all day long. They can keep doing that all day long for weeks and years and months until the first patent goes out, and then it's not their land anymore. The government can move their corners around all they want to move them around. They can reconstitute, they can resurvey, they can do a dependent resurvey, they can do an independent resurvey, they can do an original survey, and then they can wipe the slate clean and go put more monuments in the ground because there's no property rights involved. There's no property rights involved. And this all this stuff about proper procedure makes me want to pull my hair out. But there's the only reason we're talking about this manual is because, again, I'm sure they were well-meaning surveyors. They went to their legislature and said, stuff this into our code section. Let's make surveyors do this stuff. The BLM manual itself discounts any control over private practice surveyors. They said we don't have any control over private practice surveyors. The only people who have control over private practice surveyors are, I guess, us.
Okay, well, thanks, Jeff. I think that brings us, I'm going to jump way ahead a little bit here because I think what you're talking about lends us really into section 7.03. We're getting into the discussion of original surveys. We set up the base of the hows and the whys. There's tons of manuals. There's some great references in the book, different acts and letters of instruction. But with that, I think great time to jump into 703. So to kind of reiterate what you said and what you wrote in the book here, any study of the original surveys of the PLSS must begin with the instructions under which the GLO BLM surveyors were working. And then the most comprehensive collection of letters and instructions to the district and deputy surveyors that I am aware of is found in this work, the previous slide work of Albert White, The History of the PLSS or something like that. I'm not seeing it right here. And I think in the past we've linked to that in previous sessions of Wisdom Wednesday. And then another decent collection of original instructions was compiled by Roy Minnick in his book called The Collection of Original Instructions to Surveyors of the Public Lands. And then Jeff, you've got in here your own collection specific to Alabama under Alabama boundary law. But it says in here, the 1973 and the 2009 manual describes 4 general types of surveys. There's the original survey, the dependent resurvey, independent resurvey, and then the retracement surveyor. And I'm just curious here if someone would willing to speak up and talk about, well, 2 of these all cover original being the first survey, right? The original of that. But for our younger surveyors that might be watching this later, this independent and dependent surveys are something that is a newer topic that we don't talk about too much in the private sector, but the BLM manual does address that. Does anyone want to kind of give a quick synopsis of what those are for our younger surveyors?
Well, I will. A dependent they do these resurveys because the original survey was somehow flawed. It could be for any number of reasons, but so a dependent resurvey, just think in terms of a township, a dependent resurvey, they're going to wipe the slate clean as much as they can. The federal government, going to wipe the slate clean as much as they can. But in a dependent resurvey, they have properties that have already gone out from the federal government into private ownership. So they have to they're going to reconstitute the as many of the full lots, full sections as they can, and they're going to go back in there. And it's a type of original survey. It's a type of original survey because it's the survey that the patents will go out on. And I've had some arguments with some BLM people about that in a case. They said, well, it's not an original survey. Well, where does the patent come out of? From a dependent resurvey. It comes out of the resurvey of the township. That's where the patent comes out. It's not an original survey. It is an original survey. It is the original survey where the where the future patents will come out. So it's dependent upon the patents that came out from as a result of that first original survey. And independent is basically maybe you're doing they're just wiping the whole township. There's no private property. They're just wiping the whole township clean. It's independent. They're just redoing it. And that will be the survey where the patents will come out. So it's a type of original survey. And then there's a retracement survey, and that's, it's just what it says. It is. According to the manual, if you're doing a retracement survey, you can't call a corner. You can rehabilitate corners, but you can't call a corner lost. And it's what you would think a retracement survey is. They're trying to find where the old lines were, where the original lines were.
Thanks, Jeff.
Well,
You got your hand up, Dave.
My question was, Jeff, how many of these dependent resurveys or independent resurveys were done? Are we talking about 10, 50, 100 of these? Or how many roughly?
Sure that I'm sure I don't have a stat for you, but I'm sure there are a lot of them. They had a lot of problems. I mean, there was fraud, in some places.
Huh.
There were the Barstool surveys. I mean, you guys out west are familiar with some of those fiascos. Those all had to be resurveyed.
Okay.
My local library has a couple of bound volumes that have the territorial papers of Arkansas. And about 1930, when all the survey was going on, that was right before we were admitted to a state in 1836. And so a lot of the stuff that was going on was either Indians or it was surveys. That was a basic subject of most of the interaction or papers that Arkansas people were writing to Washington about. And I happened on one surveyor. It was remarkably like it is today. They weren't government surveyors. They were surveyors that were under contract to the government. And this one guy was really hot because he and some of his buddies who were real surveyors were being given the job of surveying property that was good farming property, that was important, that people would want to buy. But this was also the areas where if it was good land for farming, it was grown up in switch cane and sawbriars to the point that a man could hardly get through it. And the contracts for upland surveys in prime forest, where it was like a park where the canopy had killed out all of the underbrush, those contracts were going to somebody that had connections to the territorial governor. And those surveys were like kind of Mr. Lucas is talking about there. They weren't real surveys in a lot of places, but I was lucky that most of the township I worked in were done by some pretty good surveyors. And the only problem there they used a chain that was pretty worn, and that made the chain that they were measuring with longer than it should have been. And you would find that the distance between section corner and quarter corner would be on the neighborhood of about 15 to 20 feet longer. And that was pretty uniform. You could go find that in most all of the sections that I had occasion to work with. So they were pretty good surveyors. They just had a chain that wasn't really good. Now, when it comes to actually surveying, I know y'all think that some of these old surveyors didn't know what they were doing, but that's not exactly the case. I talked about a surveyor that started out in the 1895. I had occasion to survey, tag along with my father, who did surveying in the 1950s. And we could start at an established quarter corner and run a mile to the other quarter corner, and we might be off by 20 feet or so angle wise, but we could go back then and adjust over that mile of line. And I venture to say, probably when we crossed around the center of the section, we probably weren't offline more than a couple of 3 feet. So this idea that a lot of these things, center of sections, were set, or you find adjoining owners that are honoring a monument that's 50 foot or 100 foot out of that intersection point is quite common. But it wasn't because the surveyors couldn't do it. It was because the surveyors didn't do it. It was somebody else. It was a forester, or it was a landowner himself, or somebody that just stumbled over a rock and said, "This is a good place for our corner." So, but regardless of how they use that, if the people around that corner have used it, they have adopted it, they have ratified it, they have validated its use for their property. They have used it quite often to give a deed to other smaller tracts around them in the center of the section. But there is no way that their use of that erroneous corner should affect somebody that's a quarter of a mile away who has no part of that. And like let's say that we take this hypothetical section, and there are 4 quarter corners that that haven't been prorated. They are been relocated, or I won't say relocated. They have been retrieved from information, and they are for all intents and purposes, the exact original location of those quarter corners. If you run those things line to line, you get the boundary between the north half and south half, and between the east half and the north half. If then you get a client that, let's say, is owns the southwest quarter of the northwest quarter, he's got a southeast corner that's on the midline of that east-west section, but it's a quarter of a mile west of where the intersection, or where the center of the section is. Now, let's say those guys over there at the center, they have adopted a corner that's, let's say, 100 foot slightly northwest of where the intersection really is. Okay, that's fine for them. But that guy over there that I'm surveying for, he didn't have any part of that business over there at the center of the section. He had nothing to say about what those people over there wanted to use for their corner. And he can't be divested of his rightful corner or his rightful property, which means that he gets his standard half of over to the actual intersection point, and not just you don't set his corner based off of the erroneous monument that is now being used by the adjoining owners to the center of the section. It wouldn't be fair to him. He loses property, and he didn't have any say-so over it. That won't work. You've got to have, in those cases, you've got to recognize that at the center of the section, that monument that everybody is using is what you have to use. But if you go away from that and get into an area of the section that that landowner didn't have a part in that erroneous thing that was going over in the center of the section, you cannot hold him to what those people did. And
James,
so
I think I might disagree somewhat with what you're saying there. I mean, for me, a lot of this is evidentiary procedures, right? It's the balance of, this is what the book says, this is what he has his rights to, but it's hard to have this discussion without getting into the evidence of it, what has been occupied versus what was intended there, and if I hear you correctly, what I hear you saying is you might be setting a new center of corner to calculate off the 16th corner so that your landowner holds
That's
his
correct.
rights?
That's correct. You set the 16th corner for your client based off of the standard breakdown of that section. And you leave those people over there at the center of the section to use the corner that they have been using for years. You don't go over there and start telling those people that they've been using the wrong corner. I wouldn't even set the corner monument at the center of the section. That would be craziness. Those people over there have committed themselves to some whatever they've been using. But the fellow that you're serving for has not committed to that use that they made.
I think we'd have to get into case by case, but I think generally I would disagree with that approach. So you can't reset a corner to calculate off of because rights are tied to that. You could be creating gaps or overlaps unintentionally by resetting or remonumenting that center corner by the math in order to do that. John, you unmuted yourself. Do you want to add to that?
Yeah, I may kind of side with you, Trent. The problem you have is, you're talking about, okay, let's say the center section corner is to 50 feet off. Well, then the east and west 16th corners, what do you do with those? What do you do with that extra 50 feet or the shortage of the 50 feet? And who's going to get the record distance? If you say the guy in the southwest or the northwest gets you're going to set the west 16th corner at the correct position, then the guy on the southeast ends up taking the entire brunt of that establishment on the center section. And I think where I would go with eventually you're going to have jogs, you're going to have overlaps, you're going to have skewed lines, and this thing's going to be you're pushing errors around the interior of the section, where and I think where my brain goes is that we want to call these things erroneous corners. They're not. Once they're established, just like the manual says, once you establish that obliterated corner or that lost corner or that once you reestablish that corner position, it is to be treated as the original position without error. And when you take that concept, well, then you break it down line by line and corner by corner. You can attribute the excesses and deficiencies where they fall, so that everybody shares in the brunt of those survey errors or mismeasurements. And you don't end up with a bunch of dramatically skewed lines and stubs and such. There's just, but then, like you say too, Trent, it's a lot situationally dependent too. How much error you're talking, which directions of the error, which boundary you're talking, and which boundaries which owners have actually relied upon that corner. And I respect the idea that, yeah, the people screwing up their boundaries in the southeast quarter of the section shouldn't affect the boundaries in the northwest quarter. But at the same time, that center they put that center in there or some 16th corner in the south. Do you have a different 16th corner for the north half than you do from the south for the south half? All of those questions start to come about, and
no, you don't wind up with 1/16 corner that's different than the other.
Yeah, you don't want to.
You have two things. You have the sectional breakdown, and that's to be held except in those places where people have obligated themselves by their usage or their silence or committed to a corner that is simply a boundary corner. It's not part of the aliquot part of the regular section. It gets its validity from the actions of the adjoining landowners. And if the adjoining landowners didn't take any part in validating some corner that who knows who set, they're entitled to their lands based on the aliquot parts of the section. And that's to be found from the original corners, not from something that county surveyors, at least in Arkansas, regular surveyors, timber men and whatnot, none of them had any authority to vary the rights of people that have an aliquot part of the section. Only the landowners can divest themselves of those rights, and they do so by their own actions or their silence when somebody else sets a monument.
Okay, Jeremiah, I'll let you jump in here, and then I got a couple thoughts here.
Yeah, I'm just going to steer the conversation slightly differently, and I do agree with some things on both sides of this last conversation. I find value in being able to create a mathematical model of the section when I'm doing retracements to aliquot lines, simply so that I understand how the pieces, how the descriptions in the title record are supposed to fit together. It's not actually something I'll ultimately end up using if I find evidence that's superior. I mean, a lot of the time, these descriptions that I see out here were written off of the presumption that we had a perfect section to begin with, where all of your exterior section lines are cardinal at exactly 1 mile, and everything intercepts perfectly. And so when you draft them out that way, yeah, everything fits. And then you go on the ground and you find those discrepancies of 20 to 50 feet and long-standing fences and occupation lines that don't necessarily meet the standard of that mathematical model. But at least it allows me to find the expectation of how things should fit, so that I have a way that I can explain it when I find that discrepancy. And more importantly, it helps me understand that it is an ambiguity or discrepancy in the title record that I need to address when I'm doing a private retracement. Part of what I do, I am contracted with the county here to do monument retracement and reestablished corners, and a lot of that is purely evidentiary. It's not exactly a retracement survey as it's described in the BLM manual. It's more like a dependent resurvey, but it's gathering information from landowners. It's measuring occupation lines. It's looking at evidence that's been established or long-standing. I mean, a lot of the stuff that we've discussed. And again, sometimes I'll have to go into the title record and see how these pieces were supposed to fit together 20 or 50 or 100 years ago to better understand why their lines are where they are today. So that mathematical model of the section does have some value. I'll leave it at that.
Well, thank you, Jeremiah. That's about where I was ahead as well. Ultimately, the discussion is fair and good, and I appreciate this. For our younger surveyors that might be watching this, the biggest balance in any of this is evidence, right? The whole thing we started Wisdom Wednesdays with, evidence and procedure. Waddles talked about that, but that more got into writing legal descriptions in order to fend off any of these errors that might happen, right? And being correct in our writing, and the pincushion is the ultimate effect of some of those poor legal descriptions or poor measurements. And so when I talk to my young surveyors, my crew chiefs about this, I approach it from a very much evidence one. So one of those pieces of evidence is exactly what Jeremiah brought up. Go map it out, perfect mathematical model, 1 mile perfectly square as it was, and start just plotting those out so you can get this visual. And then you've got to go walk it. And if it's still not fitting, you got to go walk it more, and you got to retrace more. But Appreciate that we can differ in our opinions, but come out with something that's good for our young servers to understand where each of us are coming from and the method so they can evaluate how they do things and look at different points of views. So to continue on for the night and get us here moving. So John did throw into the chat that you search the records. We have 1,240 dependent resurveys and then 800 dependent resurveys with a subdivision of section. So that's nearly 2,000 in Utah alone. So I think if we look at resurveys through the BLM, we're probably looking at high percentages of areas, or rather high percentages, which is really quite interesting there. Continuing the book here, Jeff talks about, we talked about this in the first couple of chapters, this transition of the original GLO and BLM surveyors. It was laid out there on the ground, and then these guys, the government was done with them, and they start moving in. They retire and they move into the private sector, working as county surveyors for their areas or private surveyors, and breaking the habit between the old BLM GLO method of doing it and the private survey method of doing it. But we get into then this this case of Dykes versus Arnold, and it's a rather lengthy portion of the chapter. So Jeff, I want to just give you a second here in our last few minutes if there's anything you want to add, if you want to start referencing in this court case. But I think this is a fairly good place to stop. We've talked a lot about bona fide rights, but when we get back in a couple weeks here, we can cover more in depth this court case and get into the crux of what we're talking about and what this discussion just was bona fide rights.
Yeah, Banks versus Arnold, just the thumbnail sketch. It was all about the center quarter, you know, and I'm amazed at the detail that this county had on these the surveys that had taken place back in 1899. I mean, we don't have that kind of information, you know, in my neck of the woods. But they knew how I think his name was Derek, how Derek, the county surveyor, set the center quarter. You know, he stubbed it in by running from, you know, east to west, and then came back on true line and put it at the midpoint. Of course, that's obviously not what federal law says. And then so then 100 years later, and this is one of the things about these cases that I don't like. There's very little discussion as to what was used by the surveyor 100 years later with GPS relative to the quarter corners. All we know is he did the sign of the cross. We have no idea if he was working off GLO corners or not. For all we know, they were locally accepted quarter corners. And he did the sign of the cross and moved the center quarter like 70 feet to the north and west. And of course, it favored his clients, and his clients, you know, gave his clients more land, and so they were all for it. But the whole argument boils down to following proper procedure, and Derek didn't follow proper procedure, and the other surveyor agreed with Derek's corner. I mean, he had what was it? He had a 4x4 cedar post that he drove 3 feet into the ground. I mean, who has that kind of detail? But anyway, so the side the side that hired the surveyor who went out there and moved the center quarter, you know, they were all about, yeah, you got to follow proper procedure. You got to follow proper procedure. He broke the section down the way you're supposed to break it down. And then the court says, where are you reading that? We've never heard, we don't know what you're talking about. That's not what the manual says. The manual is silent on how many times you break that section down. It doesn't say you do it 15 times. It doesn't say you do it and you keep doing it until you get it right. It just says when someone subdivides a section 3-87, 1973 manual, You run straight lines between, the opposing quarter corners. Um, what's the big deal that? So somebody did that. How many times do you got to do it? And you got to do it every time. Well, this case pretty much a little common sense was brought to the table. The court basically says, we don't know what you're talking about. We don't like what you're talking about. We don't know where you're getting that information from, but you're not getting it out of this manual. So that's kind of a thumbnail sketch.
Okay. Well, wonderful. Thank you guys for the great discussion and the back and forth today. I think this has been great. So, Trent, I can't remember what our schedule looks like in March.
We're going to do March 10th will be March 12th will be the next one. So we have all three that week: mentoring Mondays, roundtable Tuesdays, and wisdom Wednesdays. March 10th, 11th, and 12th that whole week. So,
Okay.
Yep.
Great. We'll come back with some great discussion then, and we'll start with finish up the court case and some bona fide rights.
that's great.
Thanks, guys. Have a good
Have a
night.
good evening.
Bye, guys.